Gas station has people talking about what qualifies as self-defense under South Dakota law.
Now it's up to the Minnehaha County State's Attorney's Office to decide if a man who shot 3 people, killing 2, was protecting himself or committing a crime.
Police are going to look at it. Once we're done with the investigation, the State's Attorney's Office is going to review that as well. So just because there's allowances in state law for self-defense doesn't mean that there couldn't be some charges.
In some situations, if someone threatens you, South Dakota law allows you to stand your ground and fight back, and even use deadly force. The Stand Your Ground law passed in 2021, but attorneys are still reinventing their playbooks on how they handle self-defense cases going forward. KELOLAND's Carly Phillips talked with an attorney about how the law works and when it applies.
Late Thursday night, a father and son armed with bats confronted a man who they thought was someone else. According to court documents, he told investigators when the father and son started swinging the bats at him, he shot them in self-defense. Under South Dakota law, a person is justified in using or threatening to use deadly force if they reasonably believe it's necessary to prevent a forcible felony. The Stand Your Ground law does not apply if you are doing something illegal.
If you broke into somebody's house, you wouldn't have the right to stand your ground. But if you were out at a public place that you had every right to be at, and somebody walked up to you and was threatening you, threatening to assault you, threatening to rob you, you would have the right to use deadly force and be justified in that.
This means a person can't be prosecuted, meaning they can't be arrested, charged, or indicted if they were standing their ground. But this doesn't always happen, and when a person is charged, it's up to their attorney to file a motion.
If you think about what the word stand your ground is, that means I'm going to stand here and I'm going to eliminate the threat. So it really does give a lot more discretion to the person who is standing their ground of what they think, they need to do to eliminate that threat. Certainly a prosecutor, if they're going to charge someone, can come in and say, hey, we think this was excessive. We don't think that this was standing your ground.
If charges are filed and a case moves forward, a jury may ultimately decide if it's a case of self-defense. Carly Phillips, KELOLAND News.